Welcome to Sound Unlimited for all things newsy, juicy, sporty, tasty, and more.
Most of us have been following with keen interest the Judicial Conduct Tribunal's probe into allegations of sexual harassment against Judge President Selby Mbenenge. And during its last sitting, the tribunal decided to allow an expert on gender issues at the request of the evidence leader to come and testify. Advocate Skakani from Mbenenge objected to this request on the grounds that the expert witness evidence would be irrelevant to this matter. Nonetheless, the tribunal made a ruling that the expert witness should testify. Now, let's understand why the tribunal decided to allow the expert witness to testify.
One aspect on which there's been some disagreement is whether or not she should be allowed to come and testify at all, whether today or tomorrow or June or whatever. And the parties could not agree on that one, and we are here to give a ruling on that aspect as well. One of the arguments raised by Advocate Sikakane was the issue of relevance of the evidence by the expert and its materiality perhaps to the matter at hand. But on the other hand, there has been some counter-argument to say that the evidence is relevant and material. So having considered the matter properly, we are the view that we should rather err on the side of caution, rather allow evidence, even though there is argument about its relevance, allowed it nevertheless to be given. We allow it to be given because we are confident that if it is irrelevant, we'll be able to hold accordingly at any time, even at the end of that particular evidence, we will say it is irrelevant and then we will put it aside. Contrast that with a situation where you exclude evidence, which might well be relevant and material. We think that in that case, we would have erred. So like I said, we want to err on the side of caution. Our resolve is that we should allow her to give evidence. And as I've said, if it turns out to be irrelevant, we are competent, I believe, to deal with it, and there will be no prejudice to anybody. For these reasons, we conclude that she should be allowed to testify, subject to the guidance that the tribunal gave some weeks ago, a week ago, and again yesterday, and again this morning. That being said, therefore, the ruling is that she should be allowed to testify. The details of the timetable as to when document or other copies of evidence may be exchanged between the parties is a matter that can be sorted out either in chambers or amongst the parties.
In most cases, a witness's opinion is not admissible as evidence because the tribunal's role is to draw its own conclusions from the facts presented. However, there are exceptions, such as expert witnesses who can offer opinions based on their specialized knowledge. Expert witnesses can provide valuable insights and analysis, but their opinions are still considered in the same manner as ordinary witness testimony, and the tribunal is not bound by their opinions.